Hello, and welcome to Mullen's Trending Now, an IP podcast, which is a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. Today, we'll be looking at approaches to intellectual property related agreements during this pandemic. I'm your host, Amy Pruett, and today I'll be joined by my colleagues, Janet Cho and Ed White, partners in our intellectual property practice group here at Williams Mullen. How are you guys doing today? Ed and Janet, do we have any extra helpers in your offices?
None right now, but I'm going to give you my Miranda warning about my teenagers who could walk through at any moment.
Yeah, same here. My daughter is doing her virtual gymnastics right now, so hopefully you don't hear the patter of feet. So
excellent. Well, mine would be doing gymnastics off my legs if they were here right now, but I made it. I snuck away to the office. So, well, I'd like to start with you, Janet, as this whole world has really been affected by the COVID-19 pandemic, and there are so many IP-related deadlines, surely during 3 months period, and expectations have started being relaxed in terms of deadlines that are required with the U.S. Patent and Trademark Office, with other agencies around the world. Is the same thing happening with intellectual property agreements, and are things kind of halting? What's going on there?
Yeah, so I would say, I think on one end in the world of intellectual property, we're seeing both in the United States and in other jurisdictions that registrants, applicants are being given some, as you said, leeway. So I think fees are being reduced if, in certain jurisdictions with filings you have to make. I know here in Virginia, they are granting some extensions on state trademark renewals. So I definitely think there's mercy and understanding and consideration when it comes to IP rights holders on a broad scale. But when it comes to IP agreements, unfortunately, what I would say is that your rights and obligations pursuant to those agreements are driven by those agreements. So I wouldn't want anyone to think, COVID-19 is just sort of generally giving me forgiveness or leeway in terms of that license I signed. I think the advice I would give is, if you're uncertain about, what your obligations are and what kind of cure or perhaps consideration you might be entitled to, given some business difficulties you may be having, is to get that IP agreement out and read it and get an understanding of, what you might be entitled to. It could be that your agreement actually covers situations such as, maybe not COVID-19 specifically, but a health crisis or some event that causes your business to decline or diminish in some way. But before we start making presumptions with agreements, I would say that generally IP agreements are not, wholesale saying if you've been affected by COVID-19, you're sort of forgiven from your rights and obligations. And so I think the best thing to do is, even outside, as would be the case outside of COVID-19, is to make sure you read that agreement and make sure you understand what your rights and obligations are.
Sure, that makes sense. So a lot of people are sheltered at home right now and might only be able to see some of their friends and family. Now, if they're collaborating and coming up with ideas and, kind of helping each other with developing kind of new products or things that might have intellectual property concerns, do they really need some kind of agreement to protect their own rights? Or is it, okay that it's just friends and family?
Yeah, so this actually is a really timely question. It's something I've been coming across increasingly, both personally and practice-wise. And my answer to this question is, there are probably two broad considerations with this issue. One is, I'll break it down into two buckets. There's sort of the considerations legally, that's one bucket. And the other bucket I would call maybe business/personal/relationship considerations. So to address the legal bucket, I would say it's always helpful to have an agreement that talks about, who owns the intellectual property at issue, or what is the intellectual property at issue. I think you can't go wrong by having an agreement that elaborates all of the contours of whatever intellectual property you and your friends and your family have created. I think it really helps clarify and set boundaries to what we're talking about. That said, I think it can be very much seen as an inhibitor to the organic, process of creating things among friends and family, to say, okay, we need to get that, agreement together, that license or that work for hire. And I think it's often something that probably does not occur very naturally among people who care about each other when they're, really in the throes of creation, to say, hey, we need to get that agreement together. So I would say, is the agreement, absolutely necessary, especially among people who care about each other and, get along well? I think the points that I would say are, think about what you're planning to do with what you've created. If what you've created is really more of a sort of a short-term, artistic work that you anticipate is going to have a short life, meaning you share it with a few people just, for the next few weeks as people kind of try to get through COVID-19, then maybe in reality, from a legal perspective, an agreement is not needed. If it's also something that you don't really plan on exploiting in any meaningful way commercially, again, maybe an agreement is not needed. And then certainly if the agreement is truly going to serve as an obstacle between all of the friends and or family involved, that people get offended and it's really going to create some sort of block to further creativity or maybe even getting the work to completion, then perhaps an agreement is not the way to go. But I would say, consider what is the work being created, consider the relationships among the people who are involved, and what are the intentions of the people involved. And I think that will drive whether or not the agreement is actually needed. But I think as lawyers, we would always say, if you can, get that agreement. Yeah. Even if it's something short, or maybe even if it's maybe an email that elaborates, okay, so you and I are the creators, you and I are going to do this. I think having some sort of record is always better than having nothing. But again, I think it's ultimately up to the friends and or family involved to determine what they feel that they need and what the risks might be if they don't actually have an agreement in place.
Yes, definitely. We talked a little bit about in the last podcast about collaborating in the music business, and there's often a lot of collaboration among friends and family, like families that are singers or in a band together. So often trying to put an agreement together for those rights might be kind of a put off or impediment to the creativity process. So if you look at what they're trying to do and the intentions, and it does look like they could merit from a written agreement, what other than what you already mentioned, like listing who the creators are and what they've done, what might be some of the other terms of that type of agreement?
Yeah, so I would say the terms would, I think, largely be influenced by what the plans are among those creators for that work. I know you just mentioned it, but I have to reiterate it. The agreement should definitely outline what is the IP at issue. Sometimes I know when you're really in the midst of that creative process, one person may think that they created the whole thing, and the other person may think, well, you only really contributed, say, a few lines to, the words of the song. I really did everything else. So I think it's really important for any agreement to really outline and drill down, what is the intellectual property at issue so there's no disagreement, but also what are the plans for that intellectual property? Is this something that, you might want to license, you might want to share or publish? And, what would be, some of the considerations for that? I will say sometimes when it comes to work like this, especially when you're really, really kind of in the throes of creativity, all of those things may not be things that you're thinking about in terms of the long-term goals of the work that you've created. So one thing you might want to say is, you sort of outline the basics in the agreement and you permit the agreement to be, relatively amendable fairly easily, so that as things come up or as things sort of unfold and develop, that you can change the agreement or add to the agreement. So I think the most important things, though, are definitely, as you said, Amy, outlining those creators or inventors, outlining the work, and then perhaps including some basics of what you intend to do with the work, and then letting the parties amend that as they need to, so that they have some freedom and flexibility going forward.
That all makes sense. Turning to you, Ed, if I'm licensing, so I've created something either by myself or maybe collaborating with friends or family, like we've been talking about. If I want to license some of that creative property or intellectual property to someone else, so I would be considered the licensor and they're the licensee. What should I be thinking about, or what should concern me about licensing my creative property during the pandemic?
Yeah, sure, Amy. And I might just shift gears a little bit because I think it might be helpful to use an analogy here, maybe in a commercial context, because I think a lot of people are worried about how businesses are going to survive and how they're going to come back from the quarantine. So I think it might be helpful in this case to think about the licensor-licensee relationship almost as a franchisor-franchisee relationship, because as you know, in a franchisor-franchisee relationship, oftentimes the most valuable asset is the franchisor or licensor's intellectual property, and the franchisee is using that intellectual property to help run a successful business based on the pattern that the franchisor has put forth. So if you think about it from those perspectives, right out of the gate, a licensor has to be concerned with whether or not their intellectual property is being maintained and used as it typically has been under the license agreement. So, for example, if you're a franchisor who has trademarks and brands that are being used in the commercial context, but the stores that identify those brands are closed right now, well, then you might need to be concerned, for example, about whether or not you can maintain your trademark registrations if you're solely basing the use that's required in the United States on your franchisee's use of the marks. So right out of the gate, I think it's important to consider how is the IP that's been licensed being used? Is it being used pursuant to the license, and can you maintain it? And then I think it's important, again, from a commercial aspect, to consider whether or not your licensee is going to be able to weather the quarantine. You can think of various examples, restaurants being one of them, where there's a strong likelihood that some businesses may not come back or may not be able to survive the shutdown. So building essentially on my franchisee analogy, a franchisor or a licensor in this case really has to consider whether or not licensees will survive, such that you can continue to rely on their future use of the IP to maintain your intellectual property registrations. And then I think important in any relationship when you have a licensor or licensee is whether or not royalties are part of that equation. And if they are, again, in the context, let's say, of a franchisor or franchisee, it's important to make sure that the licensees are properly paying the royalties during the course of the license agreement pursuant to the terms of the license agreement. Now, we all understand, of course, that business interruptions have occurred and they'll continue to occur as part of the COVID-19 pandemic. But as a licensor, you need to be on top of that. You can certainly defer those payments. You can potentially forgive those payments. But before you do that, you need to ensure that both the licensor and the licensee have agreed on those amendments to the license agreement, that the current royalty regimes are, which may very well be based on revenue streams that require minimum revenues, are still in place such that a licensor wouldn't be deemed to have given a naked license to a licensee, in essence, a license for no apparent consideration. Moving along the same hypothetical, when I think of a licensor and a licensee in the commercial context, we have to consider whether or not there's going to be brand or reputational damage should a licensee's locations close during the pandemic. If possible, licensors should relay to consumers that if a licensee is closing, that it's doing so because of the pandemic, that it's not doing so because of the lack of value or perhaps suffocation of the goodwill that consumers come to expect from that brand. And by doing that, by being very clear with your communications about how your brand is being managed during the pandemic, again, you'll save reputational damage, and your brand will probably come out stronger from the back end of these quarantines. And then finally, I think it's important to consider if you do need to terminate a licensee, or let's say, again, a franchisee post-quarantine or during the midst of the quarantine, you need to make sure that you're properly terminating the license agreement pursuant to the terms of the license. So, for example, if it's a franchisor-franchisee relationship, you want to make sure that the termination is done pursuant to the franchise agreement, because that's very critical in ensuring that if there's any holdover trademark use by the franchisor or the licensee in this analogy, that termination is done properly, such that you can continue the business very quickly, perhaps under a new franchisee, and that you can fill the void that might be left by that former franchisee to fend off potentially a competitor entering that space. So those are just some thoughts as we go through the quarantine here from a standpoint of the licensor-licensee relationship.
Great. So what are some things to be thinking about prospectively with future relationships and future IP agreements that parties are coming together now and thinking about?
Yeah, I think, and Janet touched on this a little bit earlier as far as what to think about when you're drafting license agreements. But I think one of the major points that people have thought about that's come to light in this pandemic is whether or not license agreements and other agreements, for that matter, have proper force majeure clauses. And for those who are listening to the podcast who don't know what a force majeure clause is, it's essentially a provision in agreement that includes the ability for the contracted party to be excused from their obligations in the event that the performance of their obligations becomes impossible or impracticable. And that's typically based on state law, but impossibility is usually a fairly standard one among the states. So if something becomes impossible and there's a proper force majeure clause in an agreement, then again, the party that should have performed might be excused. And so, it's important to think about in IP licensing, obviously if you're the licensor, you'd like to think that your licensee will have to perform regardless of what may come down the pike. If you are a licensee, you might want to make sure that force majeure clause is friendly to you and that it enables you in the event that something becomes impracticable or impossible, that you don't actually have to perform. Now, in the past, force majeure clauses have been pretty general. They've included things like acts of God, terrorism, war. More recently, some force majeure clauses in agreements have included more specifically things like SARS and MERS or hurricanes. But certainly going forward in the future, I think we all need to consider whether or not force majeure clauses should specifically include things like national health crises, declare pandemics, even perhaps something as specific as COVID-19 outbreak.
Absolutely. It does seem like it might become a more common occurrence in those type of clauses in the future. So other than the force majeure clauses, what are some other examples of issues that may be coming up in existing IP agreements based on this health crisis?
Well, I definitely think there's been a bit of a slowdown in some of the licenses that have been going forward, because I think people just have some unpredictability on what's going to happen economically. So I would say on the whole, the IP agreements perhaps have slowed down a bit. But I would also say that there has been perhaps an uptick in IP agreements that relate to the acquisition of IP assets. Not surprisingly, I think there are some IP owners out there who would like to sell some of their IP assets, because perhaps if they're not needed right now, that additional revenue that they might gain from the acquisition or the sale of their IP assets will help them, fortify their business going forward. So I would just say, with regard to issues or broadly with IP agreements at this point, and this is perhaps maybe more of a business tip, but if you are an intellectual property owner who has been looking to acquire certain IP assets, now is probably a good time to look into those if your business, has the strength to do that.
Absolutely. And Janet, did you have any other comments on that too? Have you seen any other issues or examples of things coming up during this time?
I think that what I've seen is intellectual property certainly relating to specific coping mechanisms relating to COVID-19, whether it be the actual containment or treatment of the disease, as well as maybe more of the administrative side of things. So helping a company institute data management or data privacy as it relates to perhaps health information and its interconnection to COVID-19. I think a lot of IP specifically relating to that or health information is something that I've seen. And I think and this is maybe a little bit removed from intellectual property, but still within, the realm or a related segment, is just data security and privacy specifically. And management of that and agreements relating to how to manage that is also something that I think is becoming increasingly important and increasingly sought after, because COVID-19 is, in the end, something that affects a person's health and implicates their personal or can implicate their personal information. So I think that agreements relating to those things are definitely something that I'm seeing more of.
Absolutely. Well, that'll wrap up our discussion about approaches to intellectual property agreements during this pandemic. I'd like to thank Janet Cho and Edward White for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future podcasts, please contact us. You can also visit our intellectual property page at williamsmullen.com/IP. There you can find out more about our whole team, as well as past episodes of this podcast and others, as well as legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. And thanks for listening. Till next time.